It always begins the same way: flashing lights in the mirror, a calm voice at your window, and then the sound no lawful carrier ever expects to hear: handcuffs locking shut. The threat is over. You did what you thought was right, but instead of going home, you are standing under police lights while everything you worked for starts slipping away. Not because you acted recklessly, not because you broke the law, but because no one ever explained what happens after the danger ends. Most gun owners prepare for the moment they might need to defend themselves. Very few prepare for the moment law enforcement gets involved, and that second moment is where lives, freedom, and futures are often lost.
Disclaimer.
I'm not a lawyer, and this isn't legal advice. Gun laws are changing fast, and they're different everywhere. Always check with a legal professional and your local laws before making any decisions. Mistake number 1: firing warning shots. It's late at night in a quiet parking lot. Two men close in fast. Billy Coward, a 50-year-old Ford worker, feels cornered. He pulls his pistol and fires, not at the men, but into the ground. He's not trying to kill anyone. He just wants to scare them away. But that single warning shot doesn't go as planned. The bullet strikes both men in the legs. Police arrive, and suddenly Billy is no longer the victim. He's labeled a deranged gunman, charged with attempted murder, and suspended from the job he's held for nearly 2 decades. He spends 18 months under electronic monitoring, and over the next 3 years, court battles drain his life savings and reputation. Eventually, surveillance footage proves the men were the aggressors, and all 12 charges are dropped. But by then, the damage is already done. The same thing happened to Marissa Alexander in Florida back in 2010. She fired one shot into the ceiling during an argument with her abusive husband. No one was hurt, but prosecutors didn't see a terrified woman. They saw a criminal. She was convicted and sentenced to 20 years in prison. It took a successful appeal and a change in Florida law before she was finally released. But that victory came years too late. How does this happen? From a law enforcement and courtroom perspective, warning shots are not seen as fear. They're seen as rage. The thinking is simple. If you were really afraid for your life, why didn't you fire at the attacker? Why shoot the floor or the sky? Courts treat warning shots as deadly force, no different than shooting a person. Even in states like Ohio, where a 2024 ruling now allows juries to consider warning shots in self-defense trials, that doesn't stop the arrest, the booking, or the thousands you'll spend trying to prove your innocence. You'll still be treated like a criminal, even if the law eventually catches up to the truth. So here's what every responsible gun owner needs to remember. Never fire your weapon to scare someone away. That is not a warning shot. That is a criminal charge waiting to happen. You are only justified in pulling the trigger when there is a clear and immediate threat of serious injury or death. If the danger is gone, you stop. If the attacker disengages, so do you. Step back. Call 911 and let the facts work for you instead of against you. Mistake number 2: using deadly force too late. If pulling the trigger too early can get you charged, pulling it too long can get you convicted. This is where many lawful self-defense cases fall apart. The rule is simple, but the consequences are severe. Self-defense ends the moment the threat ends. In Oklahoma back in 2009, security cameras captured a moment that perfectly shows how fast things can go wrong. Pharmacist Jerome Ersland was working behind the counter when 2 teenagers rushed into his store. One of them pulled a gun. Ersland drew his revolver and fired. The attackers collapsed to the floor. In that moment, his actions were justified. He stopped the threat and protected lives. But then adrenaline took over. Ersland left the scene, retrieved a second firearm from the back room, returned to where one of the teens lay unconscious, and fired multiple additional rounds. That teenager never got back up. In court, prosecutors told the jury the truth that destroyed his defense. The first shots may have been self-defense. The shots that followed were not. They were framed as punishment and execution. The result was a life sentence. A similar outcome played out in South Carolina in 2019. A store clerk defended himself during a robbery. Surveillance footage showed one of the robbers wounded and crawling away. Instead of disengaging, the clerk continued firing. Prosecutors argued that what started as lawful defense turned into retaliation. The jury agreed. The clerk was convicted of a felony. The law here is very clear. Self-defense depends on imminence. Justice Oliver Wendell Holmes wrote in a 1921 Supreme Court case that detached reflection cannot be demanded in the presence of immediate danger. In simple terms, courts understand that decisions made in the heat of a life-threatening moment may not be perfect, but once the danger is clearly over, the law expects restraint. Every shot after that point is treated as a separate criminal act. Even law enforcement officers are bound by this standard. Supreme Court rulings make it clear that police cannot use deadly force against non-dangerous suspects. Civilians are held to the same expectations expectation, often with less benefit of the doubt. So, what should you do when force is justified but the situation changes? After one or two necessary shots, you must pause and reassess. Ask yourself whether the person is still armed and whether they are still advancing. If the answer is no, you stop shooting. You issue a clear command to stay still and drop any weapon. Once the threat is neutralized, you holster your firearm, call 911, and report that you were attacked. Your goal at that point is no longer survival. It is preserving your freedom by showing that you knew when to stop. Mistake number 3, firing too early. One of the fastest ways a justified gun owner ends up in prison is by pulling the trigger too soon. That's exactly what happened in Detroit, 2013. 19-year-old Renisha McBride crashed her car and wandered to a nearby home, confused and injured, looking for help. She knocked on the door. Inside, the homeowner panicked, grabbed a shotgun, and fired through the door without warning. She died on the spot. Prosecutors found no sign of a weapon, no evidence of a threat. The homeowner, Theodore Wafer, was convicted of second-degree murder. A similar tragedy unfolded in Florida in 2015. Newman Raja, an undercover officer, approached a stranded motorist late at night. Thinking the man was reaching for a gun, Raja opened fire. The victim wasn't attacking. He was reaching for his legally owned firearm, believing Raja was a threat. The jury convicted Raja of manslaughter. And then there's the heartbreaking case of Yoshihiro Hattori in Louisiana, 1992. A 16-year-old Japanese exchange student dressed for Halloween walked up to the wrong house looking for a party. The homeowner assumed danger, fired, and killed him on the doorstep. His defense was that he felt threatened, but the jury didn't buy it. He was convicted of negligent homicide. The lesson in all these cases is simple. Feeling scared isn't enough. You need more than fear. You need a clear, immediate threat. The law expects a standard called AOJ: ability, opportunity, and jeopardy. Ability means the person has the means to hurt you, like a weapon, size advantage, or backup. Opportunity means they're close enough to use that ability right now, not across the yard or behind a locked door. Jeopardy means their actions show intent. They're moving toward you, pointing a weapon, or making threats. If even one of those factors is missing, your use of force may not be legal. The burden is on you to get it right, and hesitation is safer than assumption, because firing too early won't protect you in court. It'll put you there. Mistake number 4, using your gun to protect property. If firing too soon can land you in prison, using your weapon for the wrong reason can do the same. One of the biggest traps concealed carriers fall into is thinking they can use deadly force to defend their property. That's not how the law works in most states, and it's a mistake that can turn a victim into a felon. Take what happened in Connecticut in 2024. A vape shop owner, Joshua Marcado, was robbed at gunpoint. The thieves grabbed cash and ran, but instead of taking cover and calling the police, Marcado chased them outside with a pistol and opened fire into their fleeing SUV. One suspect was hit in the leg, another in the stomach. But police didn't treat Marcado like a victim. They treated him as the aggressor. Prosecutors called it reckless endangerment. He was charged with multiple felonies and eventually pleaded down to assault. Now compare that to the famous 2007 case in Texas involving Joe Horn. Horn saw 2 men breaking into his neighbor's house. He called 911 and was specifically told to stay inside, but Horn refused, saying, "I'm not going to let them get away with it." Minutes later, he shot both suspects as they ran from the scene. The grand jury declined to indict him. Why? Because Texas is one of the few states where deadly force can legally be used to stop certain nighttime property crimes. But even in that case, prosecutors and police made it clear they didn't believe he acted to protect life. They believed he acted to protect property. And property, in most cases, is not worth a life. That's the key difference. In many states, the law doesn't offer the same protection when you use force to protect possessions. Even if criminal charges are avoided, you can still face civil lawsuits. One case in Texas, Howley versus Gillum, proves that point. A man fired a warning shot at a thief stealing from his truck. The bullet ricocheted and killed the suspect. He avoided criminal conviction, but was still found liable in civil court and hit with a massive judgment. So here's the bottom line. If someone is stealing your stuff, don't let that moment cost you your freedom. Your property is not worth catching a felony or ending up in civil court for years. What should you do instead? Secure your property with locks, lighting, and cameras. Be a witness. Take down license plates, suspect descriptions and directions of escape. Call the police. And only use deadly force if your life or someone else's is in immediate danger. Even if you're in the right, crossing the line from defense to aggression, or from protecting life to protecting things, can erase your legal ground in seconds. Mistake number 5, talking to police without a lawyer. This is the mistake most concealed carriers make without ever realizing it. They believe that if they're honest and cooperative, everything will work out. They think explaining themselves will help. In reality, talking too much after a defensive incident is one of the fastest ways to destroy an otherwise solid case. Here's the hard rule. rule. Anything you say can be taken apart, rearranged, and used to paint a story you never intended to tell. Not later. Immediately. In Florida in 2018, Michael Draka got into a parking lot argument over a handicapped space. He was shoved to the ground, he drew his firearm and fired. When police arrived, he started talking, and then he kept talking. He gave multiple statements without a lawyer present. Under stress, small details shifted. Nothing dramatic, just normal human stress. But prosecutors used his own words to frame him as inconsistent and untrustworthy. The jury saw those statements as proof he was hiding something. The result was a manslaughter conviction. Why did police feel comfortable charging him? Their reasoning was simple. If his story keeps changing on small points, how can it be trusted on the big ones? Once that doubt is planted, the case writes itself. Here's the reality most people don't understand. Police don't need your explanations, they need your words. Anything you forget to say becomes suspicious. Anything you correct later becomes a lie. Even harmless comments like mentioning you had a drink earlier can open the door to entirely new charges. That's why silence is not guilt, it's protection. So what should you say instead? Keep it short, keep it factual, and then stop talking. You identify yourself as the victim and state that you were attacked and feared for your life. You indicate that you want to cooperate by pointing out evidence and witnesses. You request medical attention if needed, and then you clearly state that you are under stress and will not answer further questions until you've spoken with an attorney. That's it. No explanations, no play-by-play, no trying to sound reasonable in the moment. Because even when you did everything right, the wrong words can still put you on the wrong side of the courtroom. Now imagine this situation gets even more complicated. What if you weren't defending yourself at all, but trying to help someone else? Mistake number 6, trying to help and misjudging the threat. Good intentions can turn tragic if you don't know the full story. Many armed citizens step in to help, but end up targeting the wrong person. That's not heroism in the eyes of the law, that's a criminal mistake. In Colorado, 2021, Johnny Hurley heard gunfire, ran toward it, and saw a man with a rifle who had just shot a police officer. Hurley fired, stopped the shooter, and disarmed the weapon. But when officers arrived, they saw him holding the rifle and assumed he was the threat. They shot him on sight. His family later received a settlement, but that didn't bring him back. In another case, a concealed carrier mistook a plainclothes officer for a mugger and opened fire. The officer was making a lawful arrest. The gun owner was arrested and charged with assault. Prosecutors don't hold back. If you shoot the wrong person, they won't care what your intentions were. You didn't stop a crime, you created one. And your mistaken belief won't be considered reasonable if someone gets hurt. The solution is simple. Take a few seconds to observe. If it's not crystal clear who the bad guy is, don't act. Call 911 and give them details. And if you do step in, holster quickly and keep your hands visible when officers arrive. Acting without certainty can cost you everything. Mistake number 7, mixing guns with alcohol or drugs. This is the one mistake juries almost never forgive. Carrying a firearm while under the influence, even slightly, can turn a defensible situation into a felony in seconds. Impaired judgment leads to impaired decisions, and impaired decisions lead straight to a courtroom. In Minnesota, a homeowner had a few drinks, then heard a noise outside. Worried someone was breaking in, he stepped outside and fired warning shots into the air. Officers were nearby, heard the gunfire, and responded immediately. He was arrested and charged with reckless discharge of a firearm while intoxicated. Had he been sober, the response might have been very different. But the alcohol erased his credibility before he even said a word. This is exactly what prosecutors love to spotlight. In court, they'll turn to the jury and say, "The defendant admitted he was drinking while handling a deadly weapon. Would you trust his judgment?" And that one line is often all it takes to lose the case. Several states, including Ohio and Wisconsin, have upheld convictions just for being armed while intoxicated. And under federal law, unlawful drug use alone can disqualify you from owning or carrying a firearm altogether. So here's the rule. If you're carrying, stay sober. If you plan to drink, leave your firearm locked away. And if something happens while you're impaired at home, don't grab the gun. Barricade, call 911. And let law enforcement handle it, because the moment an officer shows up, even a mild buzz can turn your actions from defensive to reckless in their eyes. Your decisions in a high-stress moment will be judged by 12 strangers later. Don't let alcohol be the reason they stop believing your story. Mistake number 8, chasing the threat after it ends. When the danger runs away, your legal right to use force runs with it. Many gun owners make the mistake of thinking they can chase down a fleeing suspect and still claim self-defense. But once the immediate threat is over, the law sees you differently. Now, you're not defending yourself, you're pursuing someone, and that changes everything. In Michigan back in 2020, a man caught someone stealing a flashlight from his car. Instead of calling police, he grabbed a gun, ran after the thief, and shot him in the leg. The suspect survived, but it was the homeowner who ended up facing felony assault charges. The The judge later explained to the jury that the shooter was no longer in danger at the moment he pulled the trigger. With that one detail, his entire self-defense argument collapsed. You might wonder if stand your ground laws protect you in situations like this. The answer is no. These laws allow you to defend yourself when you're under threat. They don't give you permission to chase someone down the street and create a new confrontation. That's not standing your ground. That's becoming the aggressor. So what should you do instead? Observe. Get a clear description. Note the license plate, what they were wearing, and which way they ran. Then call 911 and let the authorities take it from there. If you made it out safe, don't re-engage. Your job now is to stay safe and be a good witness. If the attacker comes back, that's a different story. But if they're running, let them go, because chasing someone turns you from defender to pursuer, and that can quickly put you on the wrong side of the law. Mistake number 9, acting like the cop. The fastest way to lose everything, even if you had good intentions, is by trying to take control of a situation that isn't yours to handle. The moment you step into the role of law enforcement, you stop being seen as the defender. You start looking like the aggressor. One of the most well-known examples is the 2012 case of George Zimmerman in Florida. He was a neighborhood watch volunteer who followed a teenager after being told not to by police dispatch. What started as observation turned into a deadly confrontation. While Zimmerman was eventually acquitted, prosecutors branded him as someone trying to play cop. And in the court of public opinion, his life was torn apart. That case became a national flashpoint, not because of what he did in the heat of the moment, but because of the mindset he had going into it. There are many stories like this. Armed citizens holding suspects at gunpoint, threatening them, moving evidence, or trying to secure the scene before police arrive. It may feel like you're doing the right thing, but when law enforcement pulls up and sees one person with a gun giving orders, they aren't looking for explanations. They're looking for control, and they will take it back immediately. Guess who gets arrested? It's often not the actual criminal. It's the armed citizen trying to play the hero. Here's how prosecutors frame it. This wasn't defense. This was vigilante behavior, and the system won't excuse it. If you're ever in a situation where life is truly at risk, protect yourself or others as the law allows. But once the threat is over, your role ends. Don't detain unless someone's life is in immediate danger. Don't touch evidence or try to piece together what happened. And when police arrive, holster your weapon, follow instructions, and make it absolutely clear that you are not the aggressor. The moment law enforcement is on scene, step back and let them take it from there. Knowing when to act is important. Knowing when to stop is what keeps you out of handcuffs. If this opened your eyes to how fast a good decision can turn into a legal disaster, don't keep it to yourself. Share it with someone who carries. One wrong move, one wrong word. That's all it takes to lose your freedom. Stay smart, stay ready, and stay subscribed to Second Amendment Advisor so you don't miss what could protect you tomorrow. Thanks for watching. We'll see you in the next one.